Today we're going to talk about how do I exercise my Fifth Amendment right against self-incrimination. For many years, it has been the law of our land that if you are facing a potential crime or if a police officer was to question you, you don't have to say anything. You can simply be quiet, say that I don't want to answer questions, whatever, and for the most part, that was pretty well it. Well, unfortunately, we live in times now that are changing and changing fast, and if you don't understand what to do, when to do it, and how to do it, it can lead to your incarceration. Hi, I'm J.R. Dukes. Welcome to the J.R. Dukes Show. I am your host today, and we are talking about how do I exercise my Fifth Amendment right against self-incrimination. The short answer is this: don't exercise it. Instead, I want you to exercise your Sixth Amendment right. Basically, whenever you are questioned by the police, whether it is before arrest or after you've been arrested, the first thing you want to say, I want a lawyer. If you remember those words, you are going to be in a much better situation than if you make the mistakes that many people are making today. As a matter of fact, most of the attorneys that I hear on YouTube and that I hear just talking on TV, they always say take the Fifth Amendment against self-incrimination, which is not necessarily bad advice, but the advice has changed. And I guess that is something they're not aware of yet. Here's what's going on. I'm going to break it down for you in layman terms, and we're just going to lay it out. First of all, there's a case back in 2013 called Salinas versus the state of Texas. In short, Salinas, out of Houston, Texas, was accused of a double murder. In short, Salinas was interviewed by the police and was accused of a double murder in his area. The police were questioning him. He gave many answers. I believe he was interviewed for about an hour and a half. And then the police asked him, what are the chances that the casings, that the bullets that we found at the crime scene are going to match bullets, casings that we have found at your residence? Once the police asked him that question, Salinas said absolutely nothing. He just sat there and stood what we would call mute. That was a mistake. What happened is that the ballistics came back, and at that point he was charged with a crime. However, it took about 15 years to bring him into custody. So 15 years later, they put him on trial. I believe the first trial ended in a mistrial. The second trial, he was convicted, and here's the key. He was convicted in part because the police questioned him and he refused to answer any questions, and that's what the prosecutors told the jury. Now, generally, that's always been improper, and of course, he was convicted. It was appealed to the U.S. Supreme Court, and in 2013, the decision was handed down in a split decision, 5-4, in which the Supreme Court, in my opinion, wrongly ruled that indeed it was proper to bring that up before the jury, and that if you are simply silent and you do not say anything else, you do not invoke your privilege of the Fifth Amendment or other words to that effect, you can be held accountable for basically not saying anything. It can be used to convict you, and in Salinas' case, it was used to convict him of the double murders. Now, this flies in the face of 50 plus years of case law that the Supreme Court has heard. Basically, you have a court that has become more conservative, they've become more strict, and this decision was a 5-4 decision. It's unfortunate, but it is what it is, and we have to learn how to handle it in a post-Salinas world. The same year, there's another case that came out that we must talk about. This case was the United States versus an individual by the name of Gilman Rodney Long. In short, this was a case that happened on an Indian reservation, and an FBI agent, I believe it was Agent Rice, questioned him about an alleged sexual misconduct involving his girlfriend's niece. Had something to do with, he was being questioned about, did he have any kind of sexual contact with this particular girl? He told the FBI agent that at some point he was typing on his computer and that the alleged victim rubbed her breast against him when she was passing by. At some point, Gilman told the FBI agent that he no longer wanted to talk. So he said words to the effect of, I don't want to incriminate myself. That was a terrible mistake because once he was put on trial, they were able to use those words in front of the jury to convict him. It's absolutely astonishing. It has not been something that has been allowed before. There's a lot of moving parts here, but in short, you have a judge that is a former prosecutor. A lot of these judges are basically prosecutors with robes on. You have an attorney that, in my opinion, was incompetent because he did not object and do the things that he should have done properly. And, in my opinion, you have an unethical prosecutor that was using words that he's constitutionally able to throw out, like "I wish not to make any kind of further comments," and use that against him. The way I understand the pleadings and the way the case went is basically it was kind of like split the baby. The judge told the jury that, hey, he has a right against self-incrimination, yet the prosecution was allowed in closing to basically argue, use your common sense. You know what he said, and we know what it means. And unfortunately, my understanding is that his attorney did not object. And the bottom line is this guy is now in prison for life with no chance of parole. And this was upheld, unfortunately, at an appellate court level. Subsequent to this, the Department of Justice for the United States has put the other federal courts on notice that in the future they intend on putting before the jury information if a defendant chooses to remain silent or invoke their Fifth Amendment right against self-incrimination. And in my opinion, that's gone way too far. My understanding is it's not quite set in stone if that is going to hold up in all the federal courts, but one federal court has already said, hey, we will allow it. We'll just have to see what happens as time goes on, but here's the bottom line. The Supreme Court is clearly moving in this conservative direction. There is a case way back from 1999 in which one of the Supreme Court justices point blank said that if someone is silent, that was an indication of their guilt. The Supreme Court nowadays believes that if you remain silent, you must have something to hide. They believe if you're silent, you must have committed a crime. This is really, really unfortunate. The Supreme Court also believes that the best thing you can do in life is to give up your right, your Fifth Amendment right against self-incrimination. And that's just really sad. These judges, they don't live in the real world. They live in very sheltered lives, very sheltered existence. They have security. They don't even wait in line at the airport. They live in a completely different world than you and I live in. And unfortunately, this affects their decision-making skills at times. And this is one of the most clear examples. People that are not educated, people that are poor, people that don't have the resources, they tend to get caught up in the American justice system in a negative way, and they don't have the resources to get what we would consider a fair trial, a full vetting of all the evidence. Generally, when people get caught up in this and they don't have the funds to get themselves a proper lawyer, they end up having to plead. Because if they don't plea and they receive a trial, they're going to be serving a ton of time. Where if they plea, at least they may be able to see the sunset again one day, which is extremely unfortunate that is what they're faced with. But that is the reality of our system as of right now. So I want to tell you exactly what you should plead. And what you should plead, let's break it down into two different phases. The breakdown of the two different phases are as follows. Before an arrest, if the police question you, you need to plead what I said was the Sixth Amendment. Basically, you want to ask for a lawyer. That's it. I want a lawyer. You need to practice that. You need to practice that with your family, your children, your spouse, whomever. I want a lawyer. Don't answer any questions. Definitely do not do this. Do not make any comment like, I don't want to incriminate myself. I don't want to say something that could incriminate me for this particular crime, because those words can come back and haunt you at a trial. At least if you say, hey, I want a lawyer so that I can answer or look at these questions. Let's put it this way. If you say, I want a lawyer, that's going to sound a lot better in front of a jury if that information was to make it in at any case, any court hearing in the future. You're much better off with, I want a lawyer, versus the cop reporting this individual said, I don't want to incriminate myself. Kind of speaks for itself. The same applies after you've actually formally been arrested and you're brought in. You definitely want to say, I want a lawyer. You want to shut down the interview quickly. If it's me, I would say, I want a lawyer, and I wish to invoke my Fifth Amendment right against self-incrimination. You have to be very specific. I want to invoke my Fifth Amendment right against self-incrimination, period. You have to be very specific, and the Supreme Court has been very direct and very specific in their instructions. They have said clearly that you must articulate these words. You must state clearly your wish to remain silent, that you want a lawyer, specifically that you wish to invoke your Fifth Amendment right against self-incrimination. That's exactly what the Salinas individual failed to do when he just sat there mute, which was a terrible mistake, as time has shown. So, to recap, whether it is the original questioning by the police or you have been officially arrested and you're in police custody, your first thing is, I want a lawyer. That's it. If indeed you've been arrested, you're in custody, my opinion is I want a lawyer. I wish to invoke my Fifth Amendment rights against self-incrimination. That's it. You say nothing else. That is your best chance of getting a fair hearing, a fair trial. That is your best chance of not getting caught up in an investigation or getting caught up in a crime and serving time or a punishment for something you did not commit. You have to say those exact words, you have to articulate it, and you have to be very vocal. Make sure at no time do you ever lie to the police. For example, you don't want to say, oh, I don't know what you're talking about, or this is news to me. There have been many cases in which the federal government has went after individuals for lying. In other words, they say, I don't know nothing about that, and they were able to prove that you did know something about that. Again, your best friend is to say, I want a lawyer. That's it. If it's me and someone approaches me out of the blue, I would simply say, I want a lawyer. I don't answer questions. That's it. Do you have a card that I can have so that I can give it to my attorney and they'll be contacting you at a later date? A lot of times police will not stop at that point. They will continue to pepper you with questions like, well, why don't you want to talk to me? Or what's your lawyer's name? Or something to that effect. Again, don't get off message. You can ask one more time. If you have a card, I will accept it. Otherwise, I'm going to terminate this conversation. If they continue, I would say the following. Am I being detained or am I free to leave? At least that way, they know that the encounter is not consensual and you want to leave. If they say you're not being detained, then you need to leave. You need to leave expeditiously. You need to move on with your life. You got to be very careful. Police can be very tricky, and if they think you have committed some kind of crime, they are not going to let up. You have to take precautions to protect you, your family, your kids, and you need to teach what I'm telling you to your children. At any rate, I hope that this has been beneficial for you and informative. If you have any questions, be sure to drop me an email at reachjrdukes@gmail.com. I always say that you need to watch my channel so you have a free mind, and you need to learn the law so that you keep your free mind freed. Coming to you from Zephyr Hills, Florida. Always remember to have that free mind and never give up. I am J.R. Dukes.